CPC Pleadings General. Order 6 deals with the pleadings in general. Rule 1 defines pleading. Rule 2 lays down the fundamental principles of pleadings. Rule 3 to 13 require the parties to supply necessary particulars. Rule 14 to 15 provide for signing and verification of pleadings. Rule 16 empowers the court to strike out unnecessary pleadings. Rule 17 and 18 have certain provisions relating to amendment of pleadings. Pleadings. Definition. Rule 1. Pleading is defined as a plain or a written statement. According to Moga, pleadings are statements in writing drawn up and filled by each party to a case, stating what his contentions will be at the trial and giving all such details as his opponent needs to know in order to prepare his case in answer. A plaintiff's pleading in his a statement of claim in which the plaintiff sets out his cause of action with all necessary particulars, and a defendant's pleading is his written statement. A defense in which the defendant deals with every material fact alleged by the plaintiff in the plaint and also states any new facts which are in his favor, adding such legal objections as he wishes to take to the claim. Where the defendant in his written statement pleads the set-off, the plaintiff may file his written statement thereto. Again, in some cases, the defendant, after filing his written statement, may file an additional written statement with the leave of the court. Object. The whole object of pleadings is to bring parties to definite issues and to diminish expense and delay and to prevent surprise at the hearing. A party is entitled to know the case of his opponent so that he can meet it. In other words, the sole object of pleadings is to ascertain the real dispute between the parties, to narrow down the areas of conflict and to see where the two sides differ, to preclude one party from taking the other by surprise and to prevent miscarriage of justice. In the leading case of Thorpe versus Holdsworth, the judge stated, the whole object of pleadings is to bring partners to an issue, and the meaning of the rules relating to pleadings was to prevent the issue being enlarged, which would prevent either party from knowing when the cause came in for a trial, when the real point to be discussed and decided was. In fact, the whole meaning of the system is to narrow the parties to definite issues and therefore to diminish the expense and delay. Especially as regards the amount of testimony required on either side at the hearing. In Syed Muhammad versus Fateh Muhammad, Lord Halsbury said, whatever system of pleading may exist, the sole object of it is that each side may be fully alive to the questions that are about to be argued, in order that they may have the opportunity of bringing forward such evidence as may be appropriate to the issues. In Ganesh Trading Company versus Mojiram, the Supreme Court observed, provisions relating to pleadings in civil cases are meant to give each side intimation of the case of the other, so that it may be met to enable courts to determine what is really at issue between the parties and to prevent deviations from the course which the litigation of the particular causes of action must take. In Virendra Kashinath versus Vinayak Joshi, Supreme Court stated the object of the rule is twofold. First is to afford the other side intimation regarding the particular facts of his case, so that they may be met by the other side. Second is to enable the court to determine what is really the issue between the parties. Importance of pleadings cannot be underestimated. Jacob states pleadings do not only define the issues between the parties for the final decision of the court at the trial, they manifest and exert their importance throughout the whole process of litigation. Pleadings provide a guide for the proper mode of trial. They demonstrate upon which party the burden of proof lies and who has the right to open the case. They also determine the range of admissible evidence which the parties should adduce at the trial. They also lay down limit on the relief that can be granted by the court. Basic rules of pleadings. Rule 2, Subrule 1. Subrule 1 of Rule 2 lays down the fundamental principles of pleadings. It reads as under. ఇదేం ఆర్డర్ ఇది? What is the order? Pleadings. Order 6. Order 6. Rule 2. Sub-rule 1, Rule 2 lays down the fundamental principles of pleadings. It reads as under 2.1. Every pleading shall contain only a statement in a concise form of the material facts on which the party pleading relies on for his claim on the defense, as the case may be, but not the evidence by which they are to be proved. On analysis, the following general principles emerge. Pleadings should state the facts, not law. The facts stated should be material facts. The pleading should not state the evidence, and the facts should be stated in a concise form. Facts and not law. The first principle of pleadings is that they should state only facts and not law. It is the duty of the parties to state only the facts on which they rely upon for their claim. It is for the court to apply the law to the facts pleaded. Atana. The law of pleadings may any bag untai. Law of pleadings may be tersely summarized in 4 words. Plead facts, not law. Thus, the existence of a customer usage is a question of fact which must be specifically pleaded. Similarly, intention is also a question of fact and it must be pleaded. The waiver or negligence is a plea of fact and must be pleaded in the pleading. But a plea about maintainability of the suit raises the question of law need not be pleaded. Likewise, when a Hindu sons are sued for a debt incurred by the deceased father, it is not necessary to formulate the plaint the Hindu law as to the pious obligation of a Hindu sons to pay their father's debt. A construction or interpretation of a document being a point of law need not be pleaded. This is based on the principle that a judge is bound to apply correct law even if incorrect law is pleaded by a party. A mixed question of law and fact, however, should be specifically pleaded. Material facts. The second principle of pleadings is that they should contain a statement of material facts and material facts only. Though the expression material facts is not been defined in the code, it means all the facts upon which the plaintiff... It means that all facts upon which the plaintiff's cause of action or the defendant's defense depends. In other words, all those facts which must be proved in order to establish the plaintiff's right to relief claimed in the plaint or the defendant's defense in the written statement. In Uddhav Singh vs. Madhav India, Supreme Court has defined the expression material facts in the following words: all the primary facts which must be proved at the trial by a party to establish the existence of a cause of action or his defense are material facts. Recently, in Virendranath vs. Satpal Singh, Supreme Court stated the phrase material facts may be said to be those facts which a party relies for his claim or defense. In other words, material facts are facts upon which the plaintiff's cause of action or the defendant's defense depends. What particulars could be said to be material facts will depend upon the facts of each case, and no rule of universal application can be laid down. It is, however, absolutely essential that all basic and primary facts which must be proved at the trial by the party to establish the existence of a cause of action or a defense are material facts and must be stated in the pleading by the party. The distinction between material facts and particulars cannot be overlooked. Material facts are primary and basic facts which must be pleaded by the party in support of his case set up by it. Since the object and purpose is to enable the opposite party to know the case it has to meet, the absence of pleading a party cannot be allowed to lead evidence. Failure to state material facts hence will entail dismissal of the suit. Particulars, on the other hand, are the details of the case. They amplify, refine and embellish material facts. They give the finishing touch to the basic contours of a picture already drawn so as to make it full, more detailed and more informative. Thus, the distinction between material facts and particulars in one degree is one of degree. In Virendra Singh vs. Satpal Singh, the Supreme Court said, A distinction between material facts and particulars, however, must not be overlooked. Material facts are primary or basic fact which must be pleaded by the plaintiff or by the defendants in support of a case set up by him either to prove his cause of action or defense. Particulars, on the other hand, are details in support of material facts pleaded by the party. They amplify, refine, or embellish material facts by giving distinctive touch to the basic contours of a picture already drawn, so as to make it full, more clear, and more informative. Particulars thus ensure conduct of fair trial and would not take the opposite party by surprise. Whether a particular fact is or is not a material fact which is required to be pleaded by a party depends on the facts and circumstances of each case. All material facts must appear in the pleadings and the necessary particulars must be there so as to enable the opposite party to know the case he is required to meet and to put him on his guard. The rule is not of mere technicality, and therefore if a party omits to state material facts, it could mean that the plea has not been raised at all, or the court will not allow the party to lead evidence of that fact at the trial unless the court gives that party leave to amend his pleadings. The reason is that non-mention of material facts amounts to non-pleading, and therefore no cause of action arises in favor of such party. What particulars are to be stated depends upon the facts of each case, but it is absolutely essential that the pleading, not to be embarrassing to the defendant, should state those facts which will be put his opponents on their guard and tell them what they have to meet when the case comes up for trial. That it has been held that a plaintiff filing a suit on the basis of title must state the nature of the deeds on which he relies in deducing his title. Similarly, a party relying upon the fact that the notice of dishonor is not necessary, or that the woman claiming maintenance has lost her right on account of her incontinence, or that the person who has signed the plaint in a suit by a corporate body as authority under the code is bound to allege those facts in his pleadings. Facts, not evidence. The third principle of pleadings is that the evidence of facts as distinguished from the facts themselves need not be pleaded. In other words, the pleadings should contain a statement of material facts on which the party relies, but not the evidence by which those facts are to be proved. The facts are two types: facts probanda, the facts required to be proved, that is material facts, and facts probantia, the facts by means of which they are to be proved, that is particulars or evidence. The pleading should contain only fact probanda and not facta probantia. The material facts on which the plaintiff relies for his claim or the defendant relies on his defense are called facta probanda, and they must be stated in the plaint or in the written statement as the case may be. But the facts or evidence by means of which the material facts are to be proved are called facta probantia and need not be stated in the pleadings. They are not the fact in issue, but the only relevant facts required to be proved at the trial in order to establish the fact in issue. As observed by Lord Denman, it is an elementary rule in pleading that when a state of facts is relied upon, it is enough to allege it simply without setting out the subordinate facts which are the means of producing it or the evidence sustaining the allegation. Bratt also stated, I will not say that it is easy to express in words what are facts which must be stated and what matters need not be stated. The distinction is taken to be the very rule itself between the facts on which the party relies and the evidence to prove those facts. The facts which ought to be stated are the material facts on which the party pleading relies. In Virendranath versus Satpal Singh, after referring the leading English Indian decisions on the point, Supreme Court observed, there is a distinction between facta probanda, the facts required to be proved, that is material facts, and facta probantia, the fact by means of which they are proved, that is particulars or evidence. It is settled law that the pleadings must contain only facta probanda and not facta probantia. The material facts on which the parties relies for his claim are the facts of probanda, and they must be stated in the pleadings. But the fact or facts by means of which the facta probanda material facts are proved, and which are in the nature of facta probantia, or the particulars or evidence, need not be set out in the pleadings. They are not fact in issue, but only relevant facts required to be proved at the trial in order to establish the fact in issue. The aforesaid principle is well illustrated in the case of Borodile and versus Hunter. A was insured with an insurance company. One of the terms of policy was that the policy would be void if the insured committed suicide. A actually committed suicide by shooting himself with a pistol, and thereupon action was brought against the company on the policy. The policy could only plead that A committed suicide. This is facta probanda. Other facts that A committed suicide. This is facta. Other facts that A was melancholy for weeks, that he bought a pistol a day before his death, shot himself with the said pistol, and the letter was found with his address to his wife, stating that he intended to kill himself. All these are facta probancia and need not be pleaded. Similarly, it is wrong to set out admission made by the opposite party in the pleading as that the fact is only evidence. Thus, in an election petition, the plea that the cars were used by successful candidate for the purpose of conveying voters contrary to the act must be stated in the pleadings, since it is a fact in issue, facta probanda. But the facts as to from where the cars were obtained, who hired them and used them for conveyance of voters are merely evidentiary facts, facta probancia, and need not be stated in the pleadings. It is, however, not easy to express in words what are the facts which must be stated in his pleadings and what are the matters which need not be set out. The question must be decided in the light of facts and circumstances of each case. To put it differently, the dividing line between the two classes of facts facta probanda and facta probancia is often very difficult to draw, but a fact as to which there is doubt as to whether it should be placed in one class or the other should be pleaded. Simple. When in doubt, please plead. Concise form. The fourth and the last general principle of pleading is that the pleading should be drafted with sufficient brevity and precision. The material facts should be stated precisely, succinctly, and coherently. The importance of a specific pleading can be appreciated only if it is realized that the absence of a specific plea puts the defendant at a great disadvantage. He must know what the case he has to meet. He cannot be kept guessing what the plaintiff wants to convey by a vague pleading. Therefore, the pleading must be precise, specific, and unambiguous. A party cannot be allowed to keep his options open until the trial and adduce such evidence as seems convenient and handy. The words in a concise form and definitely suggestive of the fact that brevity should be adhered to while drafting pleadings. Of course, brevity should not be at the cost of excluding necessary facts, but it does not mean niggling in the pleadings. If care is taken in syntactic process, pleadings can be saved from tautology. Every pleading should be divided into paragraphs and subparagraphs. Each allegation should be contained in a separate paragraph. Date, totals, and numbers must be mentioned in figures as well as words. Rule 3 lays down that forms in Appendix A of the code should be used where they are applicable, and where they are not applicable, forms of like character should be used. The facts must be treated with certainty. In other words, they should be definitely stated as facts and should not be left to be inferred from vague or ambiguous expressions. All material facts must be stated in a summary form, as briefly as the nature of the case requires. Immaterial averments and unnecessary details must be omitted, and material allegations and necessary particulars must be included. Other rules of pleadings. Over and above the aforesaid basic rules, there are other rules of pleadings dealing with the cases of a special nature. They have been laid down in Rule 4 to 10 of Order 6. They may be summarized thus. Whereas misrepresentation, fraud, breach of trust, willful default, or undue influence are pleaded in the pleadings, particulars with dates and items should be stated. In Bishnodev Narayan versus Shivajani Rai, the Supreme Court observed, now there is one rule which is better established than another. It is that in cases of fraud, undue influence, or coercion, the parties pleading it must set forth full particulars, and the case can only be decided on the particulars as laid. There can be no departure from them in evidence. General allegations are insufficient even to amount to an averment of fraud, which any court ought not to take notice of. However strong this language in which they are couched may be, and the same applies to undue influence and coercion. What particulars are to be set out in the pleadings must depend on the facts of each case. As a general rule, so much certainty and particularity should be insisted upon as is reasonable, having regard to the circumstances and nature of the acts. To insist upon less would be to relax old and intelligible principles. To insist on more would be the vainest pedantry. As stated above, the object of pleading is to bring the parties to a trial by concentrating their attention on the matters in dispute, so as to narrow the controversy to precise issues, and to give notice to the parties of the nature of testimony required on either side in support of their respective cases. A vague or general plea can never serve this purpose. Rule 4 has been evolved with a view to narrow the issue and protect the party charged with improper conduct from being taken by surprise. Therefore, if the particulars stated in the pleading are not sufficient and specific, the court should, before proceeding with the trial of the suit, insist upon particulars which give adequate notice to the other side of the case intended to be set up. The performance of a condition precedent need not be pleaded since it is implied in the pleadings. Non-performance of a condition precedent, however, must be specifically and expressly pleaded. General departure from pleading is not permissible except by way of amendment. No party can raise any ground of claim or contain any allegation of fact inconsistent with his previous pleadings. A bare denial of a contract by the opposite party will be construed only as a denial of factum of a contract and not the legality, validity or enforceability of such contract. Documents need not be set out at length in the pleadings unless the words therein are material. Wherever malice, fraudulent intention, knowledge or other condition of a mind of a person is material, it may be alleged in the pleadings only as a fact without setting out the circumstances from which it is to be inferred. Such circumstances rarely constitute evidence as the proof of material facts. Whenever giving of notice to any person is necessary or a condition precedent, pleading should only state regarding giving of such notice without setting out the form or precise terms of such notice or the circumstances from which it is to be inferred unless they are material. Implied contracts or relations between persons may be alleged as a fact, and the series of letters, conversations and circumstances from which they are to be inferred should be pleaded generally. Facts which the law presumes in favor of a party or as to which the burden of proof lies upon the other side need not be pleaded. Every pleading should be signed by the party or one of the parties or by his pleader. A party to the suit should supply his address. He should also supply address of the opposite party. Every pleading should be verified on affidavit by the party or by one of the parties or by a person acquainted with the facts of the case. A court may order striking out a pleading if it is unnecessary, scandalous or frivolous, vexatious or tends to prejudice, embarrass or delay fair trial of the suit. A court may allow amendment of pleadings. Forms in Appendix A of the Code should be used wherever they are applicable. Where they are not applicable, forms of like nature should be used. Every pleading should be divided into paragraphs numbered consecutively. Each allegation or averment should be stated in a separate paragraph. Dates and totals and numbers should be written in figures as well as in words. Forms of pleading. Averments and pleadings should conform with the forms in Appendix A to the first schedule, but the forms in Appendix A are not statutory. Non-compliance thereof henceforth would not result in dismissal of the suit. A party would not be non-suited on that ground. Pleading in writ petitions. There is an essential distinction between pleading under the Code and the pleading under Article 32 or 226 of the Constitution. Under the Code, every pleading, plaint or written statement should state only material facts and not evidence. In a writ petition, on the other hand, the petitioner or in the counter affidavit, the respondent should not only state material facts but also the evidence in support or proof of such facts by annexing necessary orders and documents. It should be complete in itself. That is the mean. Alternative and inconsistent pleading. The expression alternative means the one or the other of the two things. It conveys a choice. A party to a litigation may include in his pleadings two or more sets of facts and claim relief in the alternative. Inconsistent, on the other hand, means mutually repugnant, contradictory, irreconcilable or destructive. One is contradictory to the other. Both therefore cannot stand. Acceptance or establishment of one necessary implies the abrogation or abandonment of the other. There is nothing in the Code to prevent the plaintiff from relying upon several different reliefs in the alternative, or to prevent the defendant from raising several different defenses in the alternative. As observed by Lindley, A person may rely upon one set of facts if he can succeed in proving them, or he may rely upon another set of facts if he can succeed in proving them. And it appears to me that to be a far too restricted construction of this order to say that he first must make up his mind in which particular line he will want to put his case, when perhaps he is very much in the dark. The underlying object of allowing alternative pleas and permitting alternative reliefs to be claimed in one litigation is to obviate the necessity of another litigation and to decide the entire controversy in one litigation only. Thus, a suit for possession of property is maintainable on the basis of title or in the alternative on the basis of lease. Similarly, a landlord can file suit for eviction of his tenant on the ground of personal requirement or in the alternative on the grounds of non-payment of rent. Likewise, a prayer for specific performance of an agreement or in the alternative a prayer for damages or compensation can be made. A court does not prohibit a party from making two or more inconsistent tests of allegations. A plaintiff may rely on several different rights alternatively. Although they may be inconsistent, so also a defendant may rise by his statement of defense without leave of the court as many distinct and separate inconsistent defenses as he may think proper. It is open to the parties to raise even mutually inconsistent pleas, and if relief could be founded on an alternative pleas, it could be granted. This is, however, subject to the provision that such pleading does not prejudice or embarrass fair trial of the suit, but a pleading is not embarrassing merely because it is set up in an inconsistent set of facts or irreconcilable pleas. Thus, a class of ownership, or in the alternative a right of preemption, or a plea of forgery, or in the alternative pleas of execution under undue influence or fraud, or a plea of grant of perpetual tenancy, or in the alternative a plea of adverse possession can be taken. Though inconsistent pleas are not impermissible, they are seen with the suspicion by the court, and the party really takes risk in adopting this method of pleading. Likewise, a party who takes inconsistent pleas and tries to establish both of them by contradictory oral evidence places himself in peril, as the evidence adduced in support of both the pleas would be conflicting, contradictory, and mutually destructive, and may hardly inspire confidence. Moreover, all the inconsistent pleas sought to be raised by a party must be maintainable at law. Thus, the plaintiff cannot pray for a declaration that a particular contract is void, and in the alternative for specific performance of the same contract, since it is not permissible under section 37 of the Specific Relief Act 1977. Moreover, such inconsistent pleas are subject to Rule 16 of Order 6, which empowers the court to strike out any matter, either in the plaint or in the written statement, which may embarrass fair trial of the suit. Finally, where a party has taken up a definite stand once and the court has given a decision on that footing, he cannot be subsequently allowed to take an inconsistent or opposite stand in regard to the above matter. In other words, a party cannot play fast and loose, blow hot and cold, approbate and reprobate to the detriment of the other side. Scruton observed, "It startles me to hear it is argued that the person can say the judgment is wrong, at the same time accept payment under judgment as being right." His Lordship added, "In my opinion, you cannot take the benefit of a judgment as being good, and then appeal against it being bad. Thus, a party proceeding on the basis of a rule as valid cannot, during the argument, challenge the validity thereof. Similarly, a party claiming right of ownership of the property in the previous litigation cannot claim right of easement in the subsequent suit. In P.R. Deshpande versus Maruti Balram, it was held at the Supreme Court that the principle could not apply to a tenant giving an undertaking to vacate the premises and not filing an appeal in Superior Court. By directing the party to give such an undertaking, no court can scuttle or foreclose a statutory remedy of appeal or revision, much less a constitutional remedy. Construction of pleadings. Form of pleading. Now, construction of pleadings. It has been uniformly held that the pleadings in India should not be construed very strictly. They have to be interpreted liberally, and regard must be had to the substance of the matter than the words or the form thereof. They have to be interpreted not with the formalistic rigor, but with the latitude and awareness of the low legal literacy of the poor people. Again, pleadings have to be read as a whole, and it is not possible to cull out a passage and to read it out of context in isolation. The intention of the party is to be gathered primarily from the tenor and terms of his pleadings as a whole. In Madanlal Gopal versus Memraj Maniram, the Supreme Court has rightly observed, it is well settled that pleadings are loosely drafted in courts, and the court should not scrutinize the pleadings with such meticulous care so as to result in genuine claims being defeated on the trivial grounds. Pleadings are not statutes and legalism is not verbalism. Common sense should not be kept in the cold storage when pleadings are construed. Parties win and lose on the negligence substantial questions, not the technical questions. Our result cannot be abettors, and the courts cannot be abettors. In Ram Swarup versus Vishnu Narayan Inter-Collegiate, it was stated, it is well settled, that in the absence of pleadings, evidence, if any, produced by the parties cannot be considered. It is also equally settled that no party should be permitted to travel beyond its pleading, and that all necessary and material facts should be pleaded by the party in support of the case set up by it. The object and purpose of pleading is to enable the adversary partly to know the case as to merit. In order to have a fair trial, it is imperative the party should settle the essential material facts so as to that the other party may not be taken by surprise. The pleadings, however, should receive a liberal construction. No pedantic approach should be adopted to feed justice on hair-splitting technicalities. It is not desirable to place undue emphasis on the form. Instead, the substance of the pleading should be considered. The reason is obvious, as stated above. 9. The rules of procedure are intended aids of fair trial for reaching a fair decision. The function is to facilitate justice and further its ends and not to obstruct it. A procedural law is not a tyrant but a servant, not an abstraction but Supreme Court. Supreme Court has an aid to justice, not a mistress but a handmaid to the administration of justice. Provisions relating to pleadings in civil cases are meant to give to each side intimation of the case of the other side, so that it may be met to enable courts to determine what is really at issue between the parties and to prevent deviation from the course which litigation on the particular causes of action must take. It is strictly submitted that the following well-known and oft-quoted
interpretation of statutes.
See, in the leading case, ఇప్పుడు లేదు తర్వాత నెక్స్ట్ సెమ్ సివిల్ కావాలి. ఇన్ లీడింగ్ కేస్ ఆఫ్ సంగ్రామ్ సింగ్ వర్సెస్ ఎలక్షన్ ఫర్ పనిష్మెంట్ అండ్ పెనాల్టీ, election tribunal must be borne in mind while interpreting procedural laws. Code of procedure must be regarded as such. It is a procedure, something designed to facilitate justice and further its ends, not a penal enactment and punishment or penalties, not a thing delegated to trip people. The technical a construction of sanctions that leaves no room for reasonable elasticity of the interpretation should therefore be guarded against. Provided always justice is done to both sides, lest the very means decided for furtherance of justice to be used to frustrate it. Thus, it has been held that the court will not dismiss the suit of the plaintiff only on the ground that the claim is wrongly described, wrong section quoted, or that proper relief is not claimed or full relief is not claimed. This does not, however, mean that the rules of pleadings are altogether ignored. The liberal construction must be confined within reasonable limits. Therefore, where the plaintiff is a practicing lawyer and also represented by a lawyer, or where a technical defense is set up against a just claim, or where an election petition charges of corrupt practices have been levelled against the successful candidate, the pleadings must be strictly construed. The court is empowered to strike out any pleading if it is unnecessary, scandalous, frivolous, or vexatious, or tends to prejudice, embarrass, or delay the fair trial of the suit, is otherwise an abuse of process in the court. In Satya Vijay Kumar versus Tota Singha, Supreme Court observed that bare reading of Rule 16 of Order 6 of the Court makes it clear the Court may order striking of pleadings in the following cases: where pleading is unnecessary, scandalous, frivolous, or vexatious. 2. Where these pleadings tend to prejudice, embarrass, or delay fair trial. 3. Where such pleading is otherwise an abuse of the process of the court. Generally, a court does not advise parties as to how they should draft their pleadings, but this is subject to radar. Rather, parties who do not offend the rules of pleadings may, by making averments, introducing pleas which are unnecessary, which may tend to prejudice, embarrass, or delay fair trial. In such cases, the courts will interfere. This power, however, must be exercised by the court sparingly. It cannot be overlooked that normally a court cannot direct parties as to how they should prepare their pleadings. If the parties have not offended the rules of pleading by making averments or raising arguable issues, the court would not order striking out pleadings. The power to strike out pleadings is extraordinary in nature and must be exercised by the court sparingly and with extreme care, caution, and circumspection. Signing and verification of pleadings. Rules 14-15. As a general rule, every pleading must be signed by the party, by one of the parties, or by his pleader. But if the party is unable to sign the pleading, it can be signed by the person authorized by him. Similarly, every pleading must be verified by the party or by one of the parties pleading or by some other person acquainted with the facts of the case. The person verifying the pleading must specify what paragraphs he is written upon his knowledge and what paragraphs he verifies upon information received by him and believed by him to be true. This is out of my knowledge, first part. This is what information I have received and I believe it to be true, second part. The verification must be signed on an affidavit by the person verifying and must contain the date on which the place at which it was signed. The person verifying the pleading should also furnish an affidavit in support of his pleadings. The objective underlying this provision is to fix upon the party verifying or on whose behalf jurisdiction is made the responsibility for the statement that it contains and to prevent as far as possible disputes. As to whether the suit was instituted or defended with the knowledge or authority of the party who has signed the verification on whose behalf it has been signed. Added by the Amendment Act 76 requires a party to the suit to supply the address or service of notice. It further provides for the stay of the suit of plaintiff for striking off defense of the defendant in case the address supplied by him is found to be incomplete, false, or fictitious. A defect in the matter of signing and verification pleadings it merely an irregularity and can be corrected at a later stage of the suit will leave the court, and the suit cannot be dismissed nor an order be passed against the party on the ground of a defect or irregularity in signing or verification of plaintiff written statement. Similarly, if the affidavit filed by the party is defective, a court, instead of rejecting it, may give an opportunity to the party to file a proper affidavit. Next, variance between pleading and proof. It is well settled that a party can be permitted to adduce evidence on the basis of the case pleaded by him in his pleading, and he cannot set up a case inconsistent with his pleading. No amount of proof can substitute pleadings which are foundations of a chain of litigating party. The purpose is twofold, that is to appraise the opposite party particularly, distinctly, and specifically. of the case he is entitled upon to answer so that he may properly prepare his defense and may not be taken by surprise. Nidra vachestunda? And to maintain an accurate record of the cause of action as a protection against the second and subsequent proceeding founded upon the same allegation. The fundamental rule of pleading is that a party can only succeed on the basis of what he has pleaded and proved. He cannot succeed on a case not set up by him. He also cannot be permitted to change his case at the stage of trial if it is inconsistent with his pleadings. Such variation would cause surprise and confusion and is always looked upon by courts with considerable disfavor and suspicion. It will also introduce a great amount of uncertainty into judicial proceedings. If a final determination of a cause is found upon inferences at variance with the pleadings of the parties, each and every variance between the pleading and the proof, however, is not necessarily fatal. Where there is foundation in the pleading and no prejudice on the other side, a party should not be denied just relief. Whether or not a particular plea has been raised must be decided by reading the pleadings as a whole, keeping in mind the substance rather than the form of pleadings. Where parties are aware of the controversy and go to trial with full knowledge that a particular question is at issue, absence of a specific pleading is a mere irregularity. Finally, a pure question of law or of jurisdiction can be raised at every stage. Objection to pleading. An objection to pleading should be taken at the earliest. If at an appropriate stage such objection is not raised, it is deemed to have been waived. This is based on time principle that in such cases, it cannot be held that the prejudice has been caused to the party raising the plea at a belated stage. Amendment of pleadings. Rule 17 and 18. General, as already stated, material facts and necessary particulars must be stated in the pleadings and the decision cannot be based on grounds outside the pleadings. But many times the party may find it necessary to amend his pleadings before or during the trial of the case. Fresh information has come to hand. Interrogatories have been fully answered by his opponent. Documents whose existence was unknown to have been disclosed, which necessitates reshaping his claim or defense, or the opponent may have raised some well-founded objections to his pleadings, in which case it will be advisable for him to amend at once his pleadings before it is too late. Rule 17. Rule 17 provides for amendment of pleadings. It reads as under: the court may at any stage of the proceedings allow either party to alter or amend his pleadings in such a manner and such terms as may be just, and all such amendments shall be made as may be necessary for the purpose of determining the real questions in controversy between the parties, provided that no application for amendment shall be allowed after the trial is commenced unless the court comes to a conclusion that in spite of the due diligence the party could not have raised the matter before the commencement of the trial. Next, object. The object of the rule is that the court should try merits of the cases that come before them and should consequently allow all amendments that may be necessary for determining the real question in controversy between the parties, provided it does not cause injustice or prejudice to the other side. Ultimately, courts exist for the purpose of doing justice between the parties and not for punishing them, and they are empowered to grant amendments of the pleadings in the larger interest of doing full and complete justice to the parties. Provisions of this for the amendment of pleadings are intended for promoting the ends of justice and not for defeating them. The Privy Council has rightly observed, all rules of courts are nothing but provisions intended to secure the proper administration of justice, and it is therefore essential that they should be made to serve and be subordinate to that purpose, so that full powers of the amendment must be enjoyed and should always be liberally exercised. But nonetheless, no power has yet been given to enable one distinct cause of action to be substituted for another distinct cause of action, nor to change by means of amendment the subject matter itself of the suit. In the leading case, Cropper versus Smith, the object underlying amendment of pleadings has been laid down by Brown, Judge, in the following words: I think it is well established principle that the object of court is to decide the right of the parties and not to punish them for mistake they make in the conduct of their cases by deciding otherwise than in accordance with their rights. I know of no kind of error or mistake which, if not fraudulent or intended to overreach, the court ought not to correct. If it can be done without injustice to the other party, courts do not exist for the sake of discipline but for the sake of deciding matters in controversy. And I do not regard such amendment as a matter of favor or grace. It seems to me that as soon as it appears that the way in which a party has framed this case will not lead to a decision of the real matter in controversy, it is as much a matter of right, a matter of controversy. It is as much a matter of right on his part to have it corrected if it can be done without injustice or anything else in the case is a matter of right. Discretion of court. Rule 17, Order 6 confers wide discretion on the court to allow either party to alter, amend its pleading at any stage of the proceeding on such terms as it deems fit. Such a discretion, however, must be exercised judicially and in consonance with well-established principles of law. The proviso as inserted by the Amendment Act 2002, however, puts further restrictions on the power of the court in allowing amendment. Applicability to other proceedings. Over and above civil suits, the provision of Rule 17 apply to several other proceedings such as execution proceedings, insolvency proceedings, arbitration proceedings, election matters, proceedings under Land Acquisition Act, claim petition. But even where the provision of the cost are not applicable, court and tribunals are competent to devise their own procedure consistent with and based on general principles of justice, equity, and good conscience.
Yes.